Hello everybody, welcome to the Presumed Innocent Project. I'm James Fifelski. And today I want to talk about the presumption of innocence. It's something so simple, yet so powerful that many of us attorneys, many of us criminal defense attorneys, fail to leverage the power of this bedrock principle. I've heard it said that complexity is the enemy of progress. Complexity is the enemy of progress. Think about that for a moment. When something seems so complex that we have to essentially solve a riddle or put together a puzzle in order to make progress, to pass over it, to get through it, it slows us down. If you have a 40-piece puzzle, like what I've been working on with my 7-year-old, instead of a 1,000-piece puzzle, you'll go faster. You'll put it together quicker. There's something more simple about 40 pieces over 1,000 pieces, obviously. So as attorneys, even though we went to law school and we took pride in the fact that we learned how to solve complicated and complex cases and problems in the law, as practicing attorneys, I think it is so important, if we want to level up our practice, if we want to have more of an impact in people's lives, if we want to effect criminal justice reform in each and every one of our cases in a way that the legal system functions more humanely, more justly, more equitably, then we have to go back to the basics sometimes. We have to remind ourselves about the fundamental principles. And one such fundamental principle in criminal law and in the criminal justice system, not only in the United States, but in countries all over the world, France, Italy, Iran, Russia, many countries operate under this basic principle that everyone accused of a crime is presumed innocent until proven guilty. In fact, this basic premise dates back to about the 6th century under Roman law, where a similar principle, proof lies on him who asserts, not on him who denies. That principle was in operation back in the 500s. Talmudic law also holds to this principle. Every man is innocent until proven guilty. Similarly with Islamic law, the principle that the onus of proof is on the accuser. It seems like such a fundamental principle, but what I find so interesting, and I actually was surprised to find this out when I started looking at this question of where did the presumption of innocence originate in U.S. law. I looked in the Constitution, I looked in the Bill of Rights, I didn't see those words anywhere. Where does it say every person accused of a crime is innocent until proven guilty? Nowhere. It wasn't until 1895, in the case of Coffin versus United States, that the court first wrote out those words in the context of, I believe, a bank fraud type case. Every person accused of a crime is presumed innocent until proven guilty. Can you believe it? That our country, the United States, if you're in the U.S., and for those of you who are not, you can go back to find out when the presumption of innocence was first incorporated into your body of law. But can you believe, for those of you in the United States, that the presumption of innocence only became a rule of law in our criminal justice system in 1895? More than 100 years after our country was founded, and a little more than 100 years ago. It's pretty astounding to me because I always took it for granted that this was something written into the Constitution, and in fact it's not. The presumption of innocence creates so much leverage for us criminal defense attorneys because it sets the groundwork that despite maybe our own human nature wanting to assume the worst from someone we accuse of a crime, or even prosecutors who want to assume the guilt of someone that they actually have the obligation of proving guilty beyond a reasonable doubt. Their own opinion, their own influence in the criminal justice system oftentimes attempts to subvert the presumption of innocence. And I wouldn't say it's out of bad faith. I think it's out of a competitiveness. I think it's out of a need to try to win as prosecutors. Prosecutors prosecute. And sometimes in prosecuting, they lose sight of the human being that is being charged with a crime. Likewise, police officers can lose sight of the human being who's being arrested. But you and I, who practice criminal defense, whether it's in America or in another country, have the obligation to remember and to plant firmly in our psyche, in our emotions, in our work, in our professional practice, the presumption of innocence for each and every one of our clients, no matter how heinous the crime that this person is charged with. Because that foundational principle, that starting point in this sort of competitive race of justice between prosecuting attorney, defense attorney, and a judge or a jury, requires that we at least presume the best from the person who's accused in order to make sure that the process is fair. It's easy to assume guilt. It's hard to presume innocence. And yet that is really one of the chief principles that if we want to make a greater impact in the criminal justice system, we have to leverage. Not just have to, but we get to. It's essentially a gift. The principle of the presumption of innocence is a gift because it means that we go in essentially winners on behalf of our clients. They're presumed innocent. It's the prosecutor who has to climb the hill and overcome that presumption of innocence. And I've used that analogy with so many juries. The presumption of innocence is like a big hill that the prosecutor has to climb up in order to convince a jury of my client's guilt. They have to get to the top of the mountain and just over the peak in order to overcome the presumption of innocence. There is so much power, so much more leverage that we can harness as defense attorneys when we simply look at this very basic, very simple, yet very powerful principle in our practice. And that's why I have written a book about this, Presumed Innocent, because in my own practice of almost 20 years, I've learned how important and how powerful the basic principles are. Not only the principles of law, like the presumption of innocence, but basic principles of humanity. Because we are human beings when we're attorneys, whether defense attorneys, prosecuting attorneys, or attorneys that become judges. We are human beings working in this sort of organization managing people's lives whenever their lives encounter a conflict with the law. And the law is there to help create order. And so we're part of an order management system, if you will, whenever we practice law, whether it's the criminal justice system or civil litigation. So if you're interested, I'm just going to make a quick encouragement here. Check out this book, presumed-innocent.com. I'll put the link down at the bottom of the screen. I've written it for other criminal defense attorneys out of my own experience working with high-profile attorneys and discovering and developing principles that have taken my practice to higher levels than I ever expected. But enough about that. I want to end this short video by talking to you, I guess reminding you how much of an influence you as a defense attorney can have not only on the operation of the criminal justice system, but on the rules and the principles and the nuances of the criminal justice system. What do I mean by that? You and I are professionals. We work in a legal system that is based on statute on the one hand, but also precedent, case law on the other. I think far too often when we are trained in law school, we're trained to simply learn the law, apply the law to the facts, come up with a conclusion, or assess whether the judge's conclusion in that particular case was right, in your opinion. When we get into practice, we often forget that we have such an influence on the way the law not only functions as it relates to our client's case, but also the rules that are developed in terms of precedent and case law. And we can't sell ourselves short of recognizing that we have a lot of influence on the rules that we all play by as attorneys. In other words, if you think that a particular law is not applicable to your client's case, you will go ahead and argue that, and you'll try to distinguish it for some reason so the judge doesn't apply that law to your client. Similarly, if you think a particular law is not appropriate or fair, whether it's a rule of evidence or a court rule or a case law, based on some deeper principle, some deeper sense of humanity, something like what Martin Luther King used to talk about, unjust laws should not be followed. They are not obligatory if they're unjust to the human being. And that's why he spent so much time and effort, had so much zeal to fight for changes in the law, changes in discriminatory law, changes in laws that were applied unequally to different races. So, as an example, this Coffin versus United States case where the presumption of innocence was laid out as a principle explicitly for the first time in the United States in 1895. Think about the defense attorney or defense attorneys who were arguing that case, who must have brought that principle to bear on their particular case, and then the judge picked it up and wrote that for the first time in black and white, and it became black letter law and ultimately became this huge principle that all of us then get to work within and bear protection from for our clients. So don't sell yourself short in terms of the influence that you have not only on how you represent your individual clients, but in the process of representing your individual clients, how much you can actually make the criminal justice system work more effectively, work more equitably, function more properly so that more people can have due process, more people can have equal protection under the law. And all of that just by looking at the presumption of innocence as an example. I think it's such a powerful principle, yet so simple. Sometimes we overlook the beauty and the power of something as important as the presumption of innocence in our criminal justice system. Again, if you're interested in the book, check it out. I hope it serves you. I really have taken my own experience and things I've learned from other high-powered criminal defense attorneys and put it into this book with stories and examples so that hopefully it serves you and you can learn something and then do more for your clients and also impact the criminal justice system.